Okay, I think we'll get started. I can probably talk loud enough without the microphone, but we're going to webcast the event for some people who couldn't make it today, so all of the speaking will be into the microphone. I don't know if these are on, but if we have questions, they are on. Oh, great. So when after we've done the presentation, if you have questions, please do make an effort to speak into the microphone. Thank you for coming. I'm James Pearce, a first-year representative of the American Constitution Society. During every semester, ACS does a number of bagel lunches. I apologize if you don't have a bagel. The attendance is very erratic, so I was expecting a lower number, which is great. It's exciting that you've come. Today, we will have, I think, a pretty exciting event. For those of you who don't know, there's a one-page, is this still on? A one-page sheet of information. There's one on each side of the room that will help you get some of the background to the case we will be discussing. I'll first introduce who we have up here. From the Federal Public Defender's Office for the Eastern District of North Carolina, we have the three attorneys who've been working on this case from the beginning through the district court and currently at the circuit court and perhaps beyond. That remains to be seen. Immediately here on the far left-hand side is Eric Bricknack. Next to him, Lauren Brennan, and then Jane Pearce, who's my mom, which is very exciting for me. On the far right is someone who probably needs no introduction, Professor Jeff Powell, professor of law and divinity, and a professor of my constitutional law professor as well, here at the law school. The structure of the event will be, I'll just provide about another minute or so of background. Again, if you have the sheet, you should have most of that information, but just in case you haven't had a chance to look at it, the attorneys from the Public Defender's Office will provide a bit. We'll talk about the legal arguments that they have made in this case, and then Professor Powell will inhabit the government and provide some of the counter-arguments that have been made and perhaps should have been made in this litigation up to this point. So just a brief background. In July of 2006, Congress passed a statute which authorized indefinite civil commitment of those in the Bureau of Prisons. Subsequently, more than 70 individuals, men, have been certified civilly committed under this legislation. There followed in November of that year, the first group of, was it November? The first group of individuals began to be certified and then challenged the federal government's power to do this. The state governments, and in fact all 50 states, do have laws under their police power to indefinitely detain individuals deemed sexually dangerous. But this is not something that the federal government has had the authority to, well, that's being conclusory, has done in the past. So these cases were all essentially collected in the Eastern District of North Carolina, taken to the district court. The district court ruled on it and essentially invalidated the the federal statute. This is 4248. You'll hear a lot of reference just to the number 4248. Government appealed to the circuit court. There was argument there in September of 2008, last year. And just in January of this year, the panel, it was a panel at the circuit court, upheld the district court's ruling. Did you turn off the microphone, Sonia? Upheld the district court's ruling, further, upholding the invalidation constitutionally of the statute. Yesterday, the government filed a petition for en banc hearing at the circuit court. So this is ongoing litigation. So that's just the background. As I said, the attorneys will provide the legal arguments, and Professor Powell will offer some counter arguments and perhaps some editorial comments. After that, we'll open it up for questions. Okay, so thank you.
Thank you. We from the Federal Public Defender's Office appreciate this opportunity to share this ongoing litigation in the case of United States v. Comstock. The constitutional question is this: does the Constitution allow the federal government to civilly commit and incarcerate citizens to prevent future harm? There are really three overriding litigation concerns. First is the topic: federal preventative detention power disguised as civil commitment. Second is the litigation theory. For those of you that have come in or have read our one-pager, we argued the constitutional invalidity of this civil commitment statute under Commerce Clause analysis, specifically under Lopez and Morrison. The government, however, relied primarily on a necessary and proper clause argument, and the government was particularly reluctant to identify a power, an enumerated power associated with its necessary and proper arguments. Now, by way of background, Section 18 U.S.C. 4248 authorizes the government to commit anyone in Bureau of Prisons custody as a sexually dangerous person if the government proves three elements. The first would be that the individual attempted or actually has committed criminal conduct, specifically sexually violent conduct or child molestation. Second, the individual suffers from a mental illness, abnormality, or disorder. And a little side note here is that this particular definition of a mental illness and disorder is very broad, and I may defer to someone in the audience to elaborate on that from the perspective of the mental health providers and forensic psychiatrists. So the first element, again, is criminal conduct or attempted conduct. Second is mental illness, abnormality, or disorder. That results in the inability to control criminal behavior. So the second and third elements are specifically related. These elements must be proved by clear and convincing evidence. It's a bench trial, no jury. That's what 4248 sets out. The procedural history, as James alluded to and set forth in the one-pager, we are now at the Fourth Circuit. The Fourth Circuit panel opinion was issued in January, and they basically agreed with our Commerce Clause argument to find that the regulation of intrastate violence is the province of the states. And here's where it's important to recognize the federal-state differences. Federal criminal code relies on an interstate nexus, federal jurisdiction. Most sexual contact offenses are state-based and are therefore prosecuted state by state. There are very few federal contact sex offenses. They have to involve interstate lines, crossing interstate lines, or occur entirely where there's federal jurisdiction. We do a lot of work at Fort Bragg where civilians and soldiers get into trouble. So if something occurs on the base, that can be deemed federal jurisdiction. But for the most part, as the Fourth Circuit panel recognized, the regulation, and this is what 4248 is, it's a civil regulation aimed at preventing sexual violence. And they said that really is the province of the states. The second issue that the Fourth Circuit agreed with was that looking at the Commerce Clause analysis, the three areas under Lopez, that the target of Section 4248, the prevention of sexually violent conduct, is not economic activity in and of itself, nor is it substantially related to economic activity. And specifically, I don't know how many of you are familiar with U.S. v. Morrison, which was also a Fourth Circuit case in which, again, similar to the Adam Walsh Act, there were many statutes enacted, and in that, I think they enacted some criminal statutes related to interstate stalking. But the civil remedy that was struck down by the Supreme Court in United States v. Morrison involved a federal civil remedy for gender-based violence. And we drew the Fourth Circuit's attention to the federal civil remedy for gender-based violence was not very far from a federal civil regulation aimed at preventing sexually violent conduct, both civil remedies or regulations. And lastly, the Fourth Circuit noted, and something we stressed in our briefs and in our pleadings, historically, traditionally, there's a very limited federal involvement in the care and treatment of the mentally ill. There is no federal general police power, and going back for a moment to treatment of the mentally ill, historically the states exercise both what's called a parens patriae power, which allows the states to pick up someone who is a danger to himself and in their best interest pick them up and institutionalize them to save them. Then the states, of course, have a police power to pick up. So if you have a guy sitting outside the Bryan Center and it's 0 degrees and he's wearing his boxers, he's not necessarily breaking any laws, but he's probably not doing something he needs to be doing, and he could be very ill and could be a danger to himself. State can come in and pick him up and say, you know, we need to take a look at you. We need to see if we have some issues we could treat, et cetera. If you have some guy running through, and actually this is one of my mentally ill clients, under 4246, a gentleman ran through UC Irvine, absolutely naked apparently, brandishing a gun, threatening the chancellor. Now he was also very mentally ill, and he was picked up, could not be prosecuted because he was found mentally ill, not competent, not restorable, and he has been subsequently federally committed under 4246, but that's something the state could do under both their parens patriae and or their police power. We assert in this particular kind of civil commitment that's focused primarily on post-conviction. We have over 70 clients. They have all served their criminal sentences, but for one. So they expected to go home. They are in BOP for a number of reasons. And that's when I refer to an overriding concern is the scope of this, of individuals subject to commitment. They're in federal custody. Some are in for child pornography. Some are in for sex-related offenses. Some are in for firearm charges, drug charges, revocation conduct that has no bearing on any kind of sexual activity. And so our argument says, in a nutshell, that civil commitment for the purpose of preventing future harm is not what the federal government and not what the Constitution authorizes. That said, unless I have anyone from my team here ready to chime in, anything I've missed, Eric or Lauren?
No.
Yes.
Was one of the elements has attempted or committed sexual violence? If so, then how can you do it?
Because the element is that they have attempted or have engaged in sexually violent or conduct. So it's somewhere in the past. So we had a heartbreaking story of a young man who was a crack dealer from the West Coast, and he was in federal custody on crack dealing. He had juvenile offenses involving, or juvenile actually allegations, because in fact, first of all, that's another area altogether, but suffice it to say he had juvenile allegations of sexually improper conduct and one other state-based conviction of some sort. Ironically, and this is where I might get Dr. Tabrizi to chime in, his only diagnosis was antisocial personality disorder. So they can be in federal custody for any reason. It's at some point in their past the federal government alleges, and they do this in federal custody. You go through, once convicted, you go to sentencing, and before sentencing there's something called the pretrial services report. And again, the scope is BOP has been screening every single individual in custody, regardless of the reason for the federal sentence.
It's worth noting very briefly, there was one instance outside of our district where someone was kept beyond their release date accidentally. And the government said, that didn't matter. All that matters is that they be in custody. They need not lawfully be in custody. And there was another individual who was detained. It's a long story, but basically he had not committed any federal crime. He was being housed in a BOP facility subject to deportation. And the argument there was he's not there as a prisoner. And the government's response is, but he is in BOP custody. It need not be for criminal activity, and it need not be lawful. That's the government's position. So they are defining this extraordinarily broadly.
And now, if there are no more questions for us at this point, I would like to turn this over to allow Professor Powell the opportunity to review the government's arguments and, of greater interest to all of us, I'm sure, his take on the government arguments.
Well, let me make two initial points. One is that this case is a great example of the importance of good lawyering, because I've read now all the appellate briefs and the panel decision, and I can tell you, and I didn't know these folks before 10 minutes ago, so this is not coming out of long-standing friendship. This is a case of great lawyering beating not so great lawyering. And if justice is done in the sense of the good lawyers winning, these folks will win. The other point I want to make, initial point, is that the only thing I'm going to talk about is the question of whether Congress has the affirmative power to create 4248. I'm not going to talk about the what seemed to me very significant due process and perhaps other kinds of issues. All that said, the good lawyers, I think, are representing the wrong argument. I think that, in principle, they ought to lose, and here's why. This is the crucial fact is that this is a facial challenge that the Court of Appeals panel upheld to a federal statute in which there is no challenge to the underlying federal criminal laws. The laws that the 5 people who are the challengers in this particular case are convicted of violating, or in one case are accused of violating, are laws that great lawyers representing them have not challenged. And they haven't challenged for wise reasons, because the two laws at issue are both clearly constitutional. There's a set of laws. 3 of the people have been convicted of receiving or possessing child pornography. That is a Commerce Clause regulation of a national market. Its constitutionality, I think, is simply beyond facial overthrow. And the other 2 people, if I understand it right, one is convicted of and the other accused of violating 18 U.S.C. 2243, which is a sexual assault law that applies only to people who are within the special maritime or territorial jurisdiction of the United States or in federal custody. Once again, my friends here did not challenge the constitutionality of that and should not have, because it is plainly constitutional. So the underlying federal regulatory schemes are beyond question. All right. Now that gets us then to the provision in question, 4248. What about it? What the federal public defenders, lawyers have managed to do is get the court to look at the wrong thing, as if the 4248 were itself some freestanding authorization of the government to go out, pick up people, and put them away. But that's not what it is. 4248 is an exercise of Congress's power to enact laws that are necessary and proper. At this point, the government, while stumbling around, manages actually to invoke something that could have been useful. This is an exercise of Congress's power to enact laws that are necessary and proper as means to regulate how the executive and the judiciary go about enforcing the substantive laws that Congress has created, the child pornography laws and the sexual assault law. That's what the particular provision is. Now, it is settled law that Congress may enact regulations that govern how to deal with, how to carry out federal criminal legislation. No one would question that. And it is furthermore, I believe, settled law that one such appropriate, necessary and proper regulation is to address the question of what to do with pretrial detainees. There's an old case called the Greenwood case that isn't very well written, and the government doesn't improve matters by its handling, and our friends do a great job of making it seem irrelevant. But Greenwood, in a much more recent case called Salerno, U.S. against Salerno, is a very important case, make it clear, I think, that, number one, it is the pretrial detention because of dangerousness is a legitimate means of Congress regulating or setting up the system that enforces those laws that are within its competence, like the child pornography laws, like the sexual assault within special federal situations law. Salerno says there is a compelling governmental interest in preventing crime that can be addressed by detention where someone presents a demonstrable threat to the community. There's nothing in Salerno which concerns the Federal Pretrial Bail Act. There's nothing in Salerno that says that threat to the community must be a threat to the federal government or to federal employees or to people in federal custody. It is a threat to individuals or the community that the court says Congress has a compelling interest in pursuing. And you might say, well, wait a minute, that compelling interest that you're talking about doesn't seem to be related to any enumerated powers. Well, first of all, you've got the problem that Salerno accepts that it's a compelling governmental interest for Congress. But beyond that, the principle here is itself, broadly speaking, settled law, settled since the New Deal, as all of my first-year students know. In the exercise of its enumerated powers, the commerce power to enact the child pornography regulations, the property clause and other powers to enact the sexual assault in special federal situations law. Where Congress is exercising its enumerated powers, Congress may address, pursue legitimate governmental interests, pursue goals that themselves have nothing to do with those particular governmental powers. So its real goal is, for example, to eliminate child labor. Everyone agrees since 1941 that the child labor case was wrong to say you couldn't actually use the commerce power which you were on the face of it using because you were pursuing some goal that was beyond your purview. That's old, bad constitutional law. If you want a more recent example, think of Heart of Atlanta that upheld the civil right, the crucial title of the Civil Rights Act of 1964. No one was arguing that Congress's primary concern was somehow the regulation of interstate commerce. Everyone knew that Congress's primary concern was with the moral and indeed constitutional evil of racial discrimination, but Congress and the court itself accepting this, lacking the power directly to control private non-economic behavior that leads to racial discrimination, used the commerce power to get at it. Doesn't matter that Congress is here pursuing the goal of preventing people from, or detaining people who present a demonstrable threat to the community, because that's a legitimate and indeed compelling interest, and it's doing so in regard to, as a means, as part of its regulation of how its laws that are constitutional themselves, child pornography, special federal situations, how those laws are enforced. Now, that just gets us to pretrial detention, but I don't see anything in the logic that suggests that there's any different answer when Congress is providing for post-sentence detention. The governmental interest is the same regulatory interest in preventing harm to the community. There may be constitutional problems. I was saying to Jane right before we started, I'm deeply uncomfortable from the due process perspective with the latitude the court seems to allow government to detain people. The distinction seems to be something like this. If government is detaining people for legitimate regulatory purposes, that's okay, and that can even be okay indefinitely. If the government is detaining people for punitive purposes, then you've got a due process problem. I think that's really complicated, and I'm not sure the court's got it right. It doesn't go to Congress's power to enact the law. It goes to the due process constraints on that law. Now, the wonderful lawyers I'm sitting with have made several other arguments or ancillary arguments to support the conclusion that they have persuaded the Court of Appeals panel to reach. They have said that, well, this is to inject Congress into an area that is traditionally a matter of state police power concern. To which the answer is and has been ever since the New Deal, with the exception of 9 years between National League of Cities and Garcia. So what? If Congress is using one of its enumerated powers, the fact that it intrudes in and indeed displaces state authority, which this doesn't really displace, at least I wouldn't say it did, but the fact that it intrudes into an area of traditional state concern simply doesn't matter constitutionally. May trigger some kind of, well, we need to be clear where Congress upsets the usual federal-state balance. Well, I don't see that Congress isn't pretty clear about what it wants done here. All right. The lawyers for the challengers also suggested that the end result of upholding this statute is to conclude that Congress is unfettered. It's got no constraints on its ability just to commit people for what, whenever it wants to, for whatever reason. That's plainly overstated. Slippery slope arguments are good arguments, but they're also tricky ones because, as Justice, my first-year students know this, as Justice Holmes said with respect to John Marshall's famous "the power to tax is the power to destroy," Holmes said the power to tax is not the power to destroy while this court sits. And this court, or the courts, are still sitting. The Due Process Clause of the Fifth Amendment puts what the court believes to be stringent restraints on Congress's ability to use detention, other than for after conviction for a crime, as a means of keeping people who are dangerous out of circulation. Those are important restrictions. I've already indicated I'm not convinced the court has got them right or is tough enough about them, but they exist. So you've got that constraint. Beyond that, I wouldn't myself think it questionable or something that anyone would deny that the underlying statute under which the federal government is proceeding against someone, has gotten them convicted in court or has charged them with a federal crime, that underlying statute has to be constitutional. If it's not constitutional, then 4248 would not be a necessary and proper means of regulating the enforcement of a constitutional law. By definition, it would be hanging there without the thing it's supposed to hang on to, and I would myself think it was unconstitutional as applied, but not unconstitutional on its face, as applied. Therefore, just take Mr. Lopez, the defendant in the great Commerce Clause case, United States against Lopez. I don't think Mr. Lopez, myself, could properly be committed pursuant to 4248 constitutionally, because he was charged with a crime for which Congress lacks the power, the affirmative power, to act. And the unlawful, the situation where the government's arguing that, well, we're unlawfully holding someone and therefore, I suppose if I was the government lawyer, I wouldn't just concede that away, but that seems to me a doubtful proposition as well. Now, the final point that the lawyers have made brilliantly in their briefs is to argue that this is just like Lopez and Morrison. Lopez, Morrison, and here, you have Congress trying to address individual, antisocial, no doubt criminal, non-economic actions. You can't, under Morrison, aggregate those. You can't put them all together and say a whole bunch of non-economic activities add up to a substantial effect on interstate commerce. That's the teaching of Morrison. Not changed in this respect by Gonzalez against Raich, although I'm a little mystified by why nobody, given how bad the government is fighting this and how well you all are, maybe I'm not surprised. But anyway, it seems to me Gonzalez against Raich ought to get a little bit more attention. It's a more recent case. But nonetheless, I don't think anything's changed about that. But the difference is that in Lopez and Morrison, once again, the substantive law that Congress enacted was beyond the scope of Congress's power. The substantive laws that are in question in these particular challengers' cases, maybe not everybody of those 70 folks who've been certified under 4248, but the 5 people who are on this appeal, those folks were convicted or charged with crimes that are clearly within the scope federal power. That's an essential difference in Lopez and Morrison, and the whole teaching of Lopez and Morrison, therefore, is simply an apposite, because the right analysis is not, does 4248 carry out the Commerce Clause or indeed any other particular clause, but rather, is it a necessary and proper means of regulating the exercise of some other law that is within Congress's power. Now, let's just assume for the moment, perhaps wrongly, that I'm right and counsel are wrong in some abstract way. I think we learned several things in addition to the fact that what you really want is a good lawyer, and these are good lawyers. The strategy of tackling 4248 on its face and trying to overthrow it as a whole, I think was a brilliant strategy, and I don't know how they settled on it, but it strikes me as exactly right. The way one might have thought about handling this is to say, well, in this particular case, there's insufficient connection or something of the sort. Or indeed, that the real point here, as I think is correct, is a due process point. But that's to put you into the buzzsaw not only of the case law like Salerno, where the court has said the due process concerns can be addressed by things like clear and convincing evidence and applying to a narrow group of people, all that sort of thing. Beyond that, you run into what is always a crucially important thing to remember. Judicial decisions are not simply the result of algebra or, feeding information to computers that come out with answers. The judges are people. The particular folks that I suspect that are on this appeal, the defendants, are folks who may very well look to most people, including most judges, as folks that are dangerous that you really don't want wandering around. If the focus, therefore, becomes on them, on their conduct, on those sorts of issues, the judges may already be halfway towards saying, well, I'm not letting them out. Instead, what counsel did was say, let's look at this in terms of structure of government, in terms of power, so we don't have what is in the end lying behind virtually all individual rights claims, which is a kind of weighing of the government's needs versus society's needs too, versus the individual's claims, but rather, is the power exist? And by getting the court to focus on that, counsel took the court's attention away from things that are bad for their clients and right on to something where, indeed, in this particular circuit, the Court of Appeals is oftentimes quite sympathetic to this sort of claim of limitation on federal power. So I take my hat off, which I'm not wearing, to counsel and think that the in-bank court ought to grant the petition for rehearing and change the result. I hope they don't.
I actually had one question just to try and get a sense of your argument. So under your logic, would there need to be the requirement that the individuals be in BOP custody? Or could the government say, we have the power to criminalize interstate child pornography, therefore we can take any citizen who we deem to be a risk for this and put them through this process?
Well, I don't think, given the way the statute's written, you don't have to reach that.
Oh, right.
So if I were the government's lawyer, I'd say, you can cross that bridge when you get there, if you ever do.
It's a prerequisite that it be in
Yes.
Yeah.
Well, this person happened to be in a BOP facility for immigration reasons, but...
The statute specifically says in relation to a person who is in the custody of the Bureau of Prisons. Would I think, if I were the judge, would I think the statute without that in it is different? I'd have to... Then it makes my argument much weaker. And here's why. Because then 4248 would no longer look like a clear regulation of how it is you go about the process of having the executive really, carry out your laws. Then it would look like more like a freestanding invitation to put people away because they're dangerous.
All right.
Okay.
Following up on that, If I understand the essence of your argument is that Section 4248 derives its constitutional authority from the constitutionally valid underlying federal criminal statutes.
Right.
Our focus is once these gentlemen are post-conviction, post-sentence, there is no more federal power as relates to any kind of prosecution. I think there's a significant difference. Post-sentence, they've been prosecuted for being a felon in possession. They've served 67 months in a BOP. They want to go home. We understand that federal in possession is a federal crime under Commerce Clause analysis. What authority, is there never an end to this constitutional authority? Once somebody has run afoul of a federal law, is that what captures them?
It's a great question. I think the answer is a due process answer. It cannot be the case, it simply cannot be the case that Congress is debarred from legislating with respect to what you do with people whose sentences are coming to an end. Congress can provide that they be released at the prison or say that they must be taken back to their home state. So we know that there's some congressional power. The issue then becomes how far does the power go? I take it that the court's analysis would, or what I think that the cases like Salerno are saying, is that if what Congress is doing is pursuing a regulatory as opposed to a punitive interest, then we don't have a due process concern, assuming you get the procedure satisfactory.
Well, I think the interesting thing about Salerno, though, is that that is tied to criminal prosecutions. And that has a beginning and an end date. And Perry is, of course, cited by the government, also dealt with the pretrial, the Bail Reform Act. And they characterize pretrial detention as civil detention. But that has a beginning and end point that's related to a federal prosecution. This 4248 is indefinite civil incarceration post-sentence. You've paid your dues to society. And that's where I agree there is no challenge to the underlying criminal statutes that got these guys into BOP custody. I look at the Bureau of Prisons as an administrative body that is tasked with executing and administering a sentence. They are not the filter of society to determine whether people are dangerous or not. Every state and federal prison and state correctional facility releases dangerous people every day. Bank robbers will come and go. Drug dealers, for sure, come and go. If that's the premise of the argument, you should look at criminal histories. And heck, anyone with a criminal history score over a certain amount should never walk out the door.
To which the answer is, that's not what Congress has done. It may be a powerful policy argument, and this, as with a lot of other things in federal criminal law, strikes me as being designed in part to play well to Congress's constituents about things that they're concerned about. But once again, it seems to me quite clear that the court has okayed indefinite detention where the predicates are met. In fact, the case is going all the way back to the old Greenwood case. Let me not forget to say something about that. And going forward to the modern cases, mental illness may be exactly the example where the court says, well, you can put somebody in what will likely be not just indefinite but permanent custody because of their dangerousness and because of their mental illness. Once again, I think that the proper analysis under the court's precedents is a due process one. By the way, the Greenwood case is an old case from the 40s or 50s or something.
50s,
yeah. It looks sort of like it really supports the government. And I think, indeed, to the extent it says much at all, it does. What the federal public defender lawyers have done is something I've told my first-year students any number of times. They've sort of taken it and shown how it doesn't really apply. It's about a different statute. The statute has different features. It's simply not opposite, even though the government keeps quoting, there's a line that the government loves for reasons I don't fully fathom, the power to prosecute or whatever it is not exhausted. What they've done is take what the government believes to be its safe harbor and show that it's not a good safe harbor. Once again, this is great lawyering. I think Greenwood doesn't actually hurt the government's argument in the extent it says anything that helps the government. But what is happening here is good lawyers are taking the other side's strong point and turning it against them.
Is there an endpoint in your analysis of the constitutional validity of 4248 is tethered or derived from the underlying criminal statute? That's the premise?
That's the way I'm analyzing it. Yep.
It does not stand alone.
No.
Is there an endpoint for an individual who has engaged in conduct that has been federally prosecuted? At what point is that person immune from 4248?
Well, by the statute's own words, if the person's not in custody. If you have left the federal government's custody, the statute on its face doesn't seem to apply.
And what about Mr. Hernandez Arenado, who has never, ever been accused of any federal crime and who's been certified under 4248? He's the Mariel Cuban.
Once again, I think, and this would be, if they do go in bank, my guess is this is at least one very likely possibility where you lose. It's the facial invalidation of the statute. In a sense, you won too big.
Mm-hmm.
There may be all kinds, I think the unlawful custody, I'm not at all convinced the government's right to defend the person who's being held unlawfully and being committed. This may not be constitutional either, although given Congress's extraordinary powers over aliens, maybe I would end up thinking it was. But what the court seems to have done is say that this statute is facially invalid, which means there are no circumstances in which it could be valid. And that's, I think, wrong. Yeah.
If your argument is that Congress has the power to regulate the underlying activity, not just regulate but criminalize it,
Right.
then why would the detention rest on the criminalization, rest on the underlying criminal statute? Why can, if Congress has power to address the underlying subject matter, why need it necessarily address it criminally and then tie the detention to that? Why can't the logic be the criminal statute proves the power to regulate the area? Now that we know that is okay to do, we know that Congress can regulate the area, can also do it through detention, so it doesn't rest on the criminal statute itself. That's why the guy in immigration custody or somebody who's charged with a crime having nothing to do with a sex offense, but there's merely an allegation, that makes the criminal statute drop out, and it's really some guy who for some reason we have some jurisdiction over because he's in federal custody can, if I show my clear and convincing evidence, try to pose this kind of threat, to then be detainable, and the criminal statute doesn't need to underlie it, it just needs to prove that it's a regulable area.
If I'm the AUSA, I think I say, Your Honor, we agree. In fact, one of the Supreme Court detention cases, Zavitas, or I don't know how to say it, is about, at least one of them, maybe two, is about detaining aliens. So, fine. Maybe the due process concerns get heightened where the government is dealing with somebody who it's not, in fact, concerned with at a level of criminal law concern. But I don't even know that. I'm comfortable with that as a constitutional outcome of my argument.
Are there any other questions? Yes.
So if the hook is necessary and proper, I understand how this detention could be necessary and proper to effectuate a conviction for child pornography. What I don't understand is how it could be necessary and proper to effectuate a conviction for drug trafficking or weapons possession. This has nothing to do with sex offenses or sexual danger. If it's linked to the
That's our
statute,
point.
why doesn't
Yeah.
Well, I think I mean, the government's response would be, you are in BOP custody. So like Professor Powell said, we clearly have some control over your body at the point of release. We have decided that out of this universe of people over whom we have control, that mental illness that makes you more likely to commit a sex offense is such a public bad that we're going to prevent that. It doesn't matter how we got control of you. But if we think you can't help but molest a child if we release you, then, we're not going to let the fact that you were in for a drug offense as opposed to interstate child pornography affect it. So I think that would be there if you buy the argument that at that instant of release we have control. And I think that's part of up here, the difference is I think we're saying that at the instance of your release, the hook to the underlying criminal statute is over. And so, they can decide whether to give you $50 in a bus ticket or they can decide whether to just open the door to the prison, but they can't decide to keep doing things to you. And I think that's some of the different sides of the table where we're sort of breaking down.
And I also think it's interesting that this federal statute is written far more broadly than most of the state. In Kansas v. Hendricks, the Supreme Court did, with a number of different safeguards, validate a state, they're called SVP, sexually violent predator laws. And the majority of those state laws require the individual to be civilly committed to be in custody on a state contact sex offense. And this is one of the startling, we think, of course, startling and serious problem with this very broad reach of this civil commitment statute. Somebody else had a question. Yes.
Follow up with what you said earlier that the federal government has validated the power of pre-conviction detention based on the underlying law.
The Salerno case, yeah.
And then this 4248 requires custody in the Bureau of Prisons and an underlying, so there's no requirement of conviction.
No.
No.
So someone could be in custody on suspicion
Mhm.
of an underlying crime, not be convicted, and then not be released.
Yep. Yes. Yes.
They were never been convicted.
Notice this, one could think this is very peculiar because it's easier for me to defend 4248 when it's applied to pretrial detention than it is for post-trial detention. And yet, the post-trial detainee, post-conviction, post-sentence detainee, is someone who at least has been convicted of a crime, whereas you're talking about the situation where someone's never been convicted of anything, and it's quite clear that at least as long as you observe due process safeguards, that the federal government may detain you because you're dangerous.
Please.
If you take it to its further stretch, the federal government can actually hold in Bureau of Prisons custody material witnesses for their cases. So theoretically, you could have somebody that was a witness in another case, and should they pose some sort of concern to the general public, they could be committed under this. So. They don't typically hold jurors in custody. No, I wouldn't think so.
So sign up for
Yeah.
jury duty, you're saying.
All right, in the back of the room, sir.
Yeah, just a thought experiment on some of this stuff. Questioning the underlying, you both conceded that the predicate criminal act is constitutional, but just to question that for a second. So the argument runs something like this. It seems that the indefinite, post-conviction indefinite detention is really part, right, if certain safeguards, or not safeguards, certain elements are met, is really part of the underlying criminal act in some respects. That is, right, if you've committed a certain act, we know that if you have a mental illness even coming in, that you are subject to be held indefinitely. All right, I mean, that seems to be correct, isn't it?
Well, I think,
Under certain circumstances, I mean,
yeah.
not everybody, but certainly within a certain group of individuals, right? So in a lot of respects, I mean, this is similar in a context in which, unsuccessfully, unfortunately, but similar idea that where they challenge post-conviction voting rights removal, right? Part of the argument there is, look, you're really punishing this is part of the underlying punishment, not something separate. This is
That's something we had actually discussed. If if we lose, if this is, and I think it was maybe a concern of the district court judge during Rule 11, the plea colloquy. Is this something that everybody would have to be sort of informed of, that as a consequence of pleading guilty, you may have, X, Y, and Z, because federal court plea colloquies are very long. And that was a concern of the district court judge. Do I have to inform every defendant that comes in front of me that this is a possible repercussion? So, I mean, I think it's a valid point that you've brought up, and it's something that's certainly been thought about.
The court purports to distinguish between the regulatory and the punitive use of detention, and due process would be offended by a punitive use.
Right, and I think that's part of the argument, right? I mean, to what extent is this really an indefinite punitive component as opposed to an administrative component? And it would raise the question of would Congress have the power to indefinitely maintain someone who met those circumstances as part of a criminal
Supervised release, isn't there?
would be,
Yeah.
to what extent can you question the underlying predicate act as opposed to saying it's automatically constitutional?
Well, I think certainly we've talked about this. You'd run into ex post facto and some issues, but if tomorrow Congress changed the law and said, this is part now of a criminal sentence, if you were convicted or plead guilty to, transmission of child pornography over the internet, you have a minimum sentence, a maximum sentence, you have supervised release, and you can be subject to indefinite civil commitment. There may be due process concerns with that, but you may know of some case. I don't know of any case where imposing something as part of a criminal sentence is outside of Congress's power. And that would certainly be a way to sort of put this on much more sound constitutional footing. But that's not what they've done. And again, I think you see what we've talked about is 4248 an independent grab of authority, or is it ultimately so tied to the federal criminal code, the vast majority of which is constitutional, that it's simply part of what Congress is allowed to do?
You have a question?
This is a function of me not having the actual section in front of me and the citation, but I wondered about the standard for defining this mental health. What I heard one member of the panel say is that it basically says an impulse disorder, which a lot of socially acceptable behaviors fall under impulse disorders. So as long as you have an impulse disorder coupled with past sexually violent act, that automatically qualifies. I just wanted someone to speak on what the actual definition of this mental health requirement is.
Dr. Tabrizi. I don't know. All right. I think what's, again, disturbing, the federal civil commitment statute 4246 deals with mental illness and resultant dangerousness, far more narrowly crafted. The definition under 48 is mental illness, abnormality, or disorder, and it embraces a vast spectrum of human behavior and will, in fact, actually raises a number of concerns that we haven't wrestled with as we go forward with this litigation. But yes, the hypo I was talking about of the young crack dealer with antisocial personality disorder, it will embrace disorders that many people suffer from. Some stats have over 50% of the inmate population suffer from this. So again, this goes to the broad reach of the statute and perhaps the due process concerns. But it's, again, very broad. So impulse disorders would be captured, absolutely.
Just to play out the logic, if Congress can regulate in the area, and Congress can decide that sexual predation is just more of a problem than bankruptcy, different type of danger, and the detention can occur without necessary prosecution under a crime, without requirement for reasonable doubt standard relative to detention, then why require mental illness at all? If isn't the mental illness just being chosen as an indicia of dangerousness? That because of this, the person's more likely to recidivate or, commit this crime at all than they would be if they didn't have mental illness. But it may be that without anything in the DSM-4, this person still would be unable to control their
I think
behavior in this way. And then isn't the mental illness requirement just part of the chosen sort of evidence for the likelihood, the dangerousness of parts of it? And if it were actually based on mental illness as a substantive element as opposed to evidentiary of dangerousness, wouldn't it be a discrimination against the mentally ill as opposed to that relative to dangerousness?
I think the short answer is the due process concerns that we didn't have time to reach today are why a large part of why the mental illness prong was in there. Kansas v. Hendricks, which is the case that said this was okay on the state level, relied heavily on the fact that this was treatment. That's what helps make it regulatory and non-punitive. It is discriminatory against people with mental illness. It is discriminatory against people who are in BOP custody. And I think the government's response is, hey, we're on rational basis review, and people who are in prison and people who have mental illness, we can certainly make a rational distinction when we're trying to decide who's going to be more dangerous going forward. But that's it. The mental illness thing, and there's a case, Fuchsia v. Louisiana, Kansas v. Hendricks, we get into preventative detention versus detention for the sake of treatment and how that interacts. And we just didn't have time today, but that's why that's there.
Detention is not part of the treatment. It's to prevent dangerousness during treatment, and the treatment is part of what makes it not necessarily indefinite or permanent.
Well, the treatment is actually a myth. The New York Times did an article, a series of articles now almost 2 years ago, and the state of Wisconsin at that point was still civilly committed. A 102-year-old gentleman was still civilly committed as a sexually violent predator. Mr. Hendricks at that point was, I don't know, in his mid-70s, wheelchair bound. For the most part, I think, and again, we're not up to speed on, we focus on different areas, but for the most part, once committed as a sexually violent predator and under state commitment programs, very few people are released. So it really is a de facto life sentence.
And indeed, the statute, 4248 itself, is written in a way that sort of lends itself to that. The discharge provision begins when the director of the facility in which a person is placed pursuant to subsection D determines.
Right.
In other words, it's the government that initiates the discharge, not the individual. It's on the face of the statute.
Yes.
No,
This is
that's
not
the
designed
case.
to let people out regularly.
This is designed to be long-term detention to prevent future harm.
So if treatment is required at all, it's to allow the prospect perhaps that it works, but it's not required.
It's really to comport probably with what the Supreme Court said in Kansas v. Hendricks. I mean, that was in fact one of the reasons they allowed this. And I mean, the statistics are pretty staggering as to how many people, I guess, have not been released after they were committed. So, I mean, it's sort of a...
And it's very different. I do the majority of the 4246 commitment work in our office, and those guys are generally, and I find a bigger distinction, which I will continue to talk with Professor Powell about later. Most of my 46 clients are pretrial, charged federally, found not competent, not restorable. They're mentally ill, they're very sick, and they often are amenable to treatment. And in fact, Dr. Tabrizi, who's with us today, is one of the independent examiners that often will evaluate our clients for the court to make that legal determination from a professional perspective. does Mr. Smith suffer from an Axis 1 narrow spectrum mental illness that results in danger to the community. That's very different. And they're in a hospital. They're getting, oftentimes they're in the process or will get care and treatment, and often are, once amenable to treatment, are released back to the community and eventually can work their way out of the federal system altogether. Not to say that we have a 100% success rate, but it's a very different type of commitment process, different type of outcome, different therapeutic needs are met. Civil commitment for sexually dangerous persons is really preventative detention.
It's an abuse of the treatment myth that you refer to. You know, the treatments aren't there. Part of the treatment, I understand, it's not my area of expertise, I promise as much as I can, is they actually have to go through therapy and say, yes, I do have a sexual arousal problem. Imagine that. Now, this is a treatment note being generated. Yes, I do have this problem, I want treatment for it, and then as a result, you're actually saying you are, I mean, that could be used as evidence that you actually did something wrong, right? I'm not an attorney, but you see the predicament these people are in. In order for them to be released, they have to participate in treatment. In order to participate in treatment, they have to say they had that illegal activity.
Is the treatment optional, or if they miraculously recover, could they be released?
No, there's not that I know of. In fact, the treatment has very, very low success rate, and it is even debatable if it has the same level of scientific evidence behind it that we have for schizophrenia, which is the 40 to 76 cases, for example, that we deal with here. It's very different. You know, I mean, I can treat someone with schizophrenia against his will, and he gets better. Correct. I can give them antipsychotics against their will. It doesn't even matter if they want it or not, as long as I'm authorized to do it. They have the same response rate. So how is this working with psychotherapy, which would be the most common form of intervention? It's very different. It's two different premises.
At this point, we've run a bit over. This is an ongoing case and certainly an ongoing discussion, but please join me in